2026 is starting with big, a big piece of news in the case of the murder of Judge Kevin Mullins, the Kentucky District Court judge that was shot dead by his former colleague, but his former bailiff. Oh my goodness. I have incepted myself, everybody. I've incepted myself. There we go. Okay. Back. Big piece of news to start the new year in the Kevin Mullins case. We're going to get into it tonight. Could there possibly be a recusal of the judge? Maybe. Let's dive in. This video contains mature themes and discussions intended only for adult audiences. Viewer discretion is advised. Well, hello there, my friend, and welcome back to another true crime conversation with me, Gavin Fish, on my self-named channel. Not all that creative about naming my channel, but here we are. And on this channel, what we like to do is dive into the nitty-gritty of true crime, cut past the fluff and the sensationalism, and just get into the real good stuff of deep dives. If that is your thing, I'm glad you've joined me. I hope you stick around. And wherever you're joining from, please leave that in the comments because I just really love to know where you guys are from. I really like it. And Happy New Year. This is our first live stream of 2026. As we're doing this, it is January 2nd. It might be a different date where you are. There's lots of fine folks in the replay crew or the rewatch crew, and I'm glad that you are. Also, if you're in the rewatch crew, please tell me in the comments where you're tuning in from. I just really, really love that. Guys, do you remember this case? This is, we've covered it at length. By my count, this is the 47th video that we have done on my channel about the murder of Judge Mullins. Let me just give you the rundown. And actually, before I really get into this, there's something that I want to know in the comments, okay? I love you telling me where you're from. I love that. But I also, it's 2026, our first live stream. I would love to hear if you have any New Year's resolutions. I have a couple things that I'm doing. I don't like to call them New Year's resolutions because I fail at New Year's resolutions every time. But I've got things that I have already started for 2026 that I mean to finish. So tell me what your plan is for 2026. Okay, here is Judge Kevin Mullins. Okay, Judge Mullins was, I don't want to mischaracterize this. I was going to say minding his own business, but he was in his courtroom chamber when in came the sheriff and shot him 9 times on camera. So this is a case of not whodunit, but it's kind of a why'd you do it case. Is there a justification for this? Sometimes there are legal justifications. I'm not asking for moral justifications. But yeah, he shot him 9 times and then kind of fled, kind of stuck around, and then gave himself up. We've covered this pretty big lengths, but Mickey Stines was the sheriff of Letcher County, Kentucky when he did this. He previously was Judge Mullins' bailiff, and he is now, the trial hasn't begun, but I think we can say he's on trial for the murder of Kevin Mullins. And so far, it looks like he's going to mount an insanity defense, a not guilty by reason of legal insanity. And I don't know. Do you think this trial will happen in 2026? Somehow I doubt it. Somehow I think, because the murder happened on September 19th, 2024. Do you see the timestamp up in the corner there? So it has been over a year, but I think this is probably about a 3-year process, right? So what we're going to do tonight, and for those of you who are new around here, one of the things that I love doing on the channel is getting into legal documents, case files. It's been a while since we've been able to do that because so many cases that are in the public zeitgeist, or so many cases that we have been following, haven't had a lot of things that have come out. Think about Celeste Rivas, or most recently the Rob and Michelle Reiner, right? We're not going to get very many documents, but in this case, we've gotten a lot of documents and I want to get into them. Before we do, let's check in to make sure that my the live chat is working for me. We've got Vermont here in the house. Glad you are here. Valparaiso. How do you say it in Indiana? I would say it Valparaiso. Because it's a Spanish word, but you guys say it like Valparaiso or something. I don't know. North Carolina is back. Glad you're here. Jacksonville, Florida, Eastern Kentucky, which is where this case takes place, is here. Terre Haute, Indiana. I'm sure that I'm mispronouncing that too, but I apologize. Let's see. If there are any Colorados in the house. Valparaiso. Is that really how you say it? Valparaiso. Okay. All right. I'm glad you're here. New York is here. That is the lovely state where my wife and I spent New Year's Day. Glad you are here. See if there's any. Yeah, put GF in your comment if you have like a New Year's resolution that you want to keep. I want to know about that. Okay. Where are we going? I know where we're going. We're going over here, which is Acrobat on my side. This is a document that was filed on December 29th in the Commonwealth of Kentucky 47th Judicial District Letcher Circuit Court, which is where this case takes place, right? Now, last time we had Elizabeth Jones on the channel, which was just last week, she told us that this was happening because there was a hearing scheduled. Everybody showed up for the hearing. There they all were. And then the judge came out and said, we have to continue this hearing. And Elizabeth told us it was because there seemed to be a reason why the judge should recuse himself, or at least I think we should say the defense thinks that. So, and oftentimes, I can't remember if I've said this on this live stream or not. I'm a little out of sorts. Let me go on a tangent here real quick, guys. Got to get a tangent in. Damn. Guys, on New Year's Eve, my snuggly bear, my sweetie pie, my one and only Kimberly Fish, she and I hopped in our brother-in-law's truck and drove to the Poconos, hauling a U-Haul trailer. And we arrived at our hotel in the Pocono Mountain region in eastern Pennsylvania, kind of late. It was like 7:30, 8 o'clock at night, with the intention of just spending the night and heading into New York City because we had wanted to help our daughter and our son-in-law move. They moved from one borough of New York City to another borough of New York City, and we wanted to help. So we went. We got to our hotel kind of in the later evening of the 31st. Zonked, like we took a shower, zonked, probably by like 9:30. And then we got up nice and early, drove into the city, and worked all day long to help them move. We did not get back into our house. I think, I don't want to overstate this, the first time I looked at the clock, it was 3 a.m. So it must have been quarter till. And then we had to get up for our work. So I just got up from the most glorious nap, maybe of my entire napping career. I mean, that was a better nap than like Thanksgiving Day naps. But I'm still foggy, man. I am still foggy. I barely got up in time to start this live stream. I should have. I'm just. It doesn't matter. It's a tangent. But anyway, I can't remember if I said this or not. I never worry about whether or not I'm first to break news. like first to share a document or something like that. What I care about is that we do a good, solid, deep dive into documents. So that's what we are going to do today. All right. Okay, let's bring up the lower third one more time and come on over to Acrobat. And here is the document that was filed on the 29th in Commonwealth of Kentucky versus Sean Mickey Stines. Verified motion to recuse/disqualify. Comes now the defendant, Sean Mickey Stines, by and through counsel, and respectfully moves this honorable court to recuse Judge Christopher Corrin, I think that's how we pronounce his name, from presiding over the matter. The motion is made pursuant to Kentucky Revised Statute, Section 26A.015 and Supreme Court Rule 4.300, Canon 3E, on the grounds that the judge's impartiality might reasonably be questioned. In support of the motion, the defendant states as follows. Now, I think before we go further, let me get my little highlighter here. Impartiality might reasonably be questioned. So I think it would be overstating it for us to say the defense, in this case, the lawyers, by the way, are Jeremy and Carrie Bartley. These lawyers have impressed me as a non-lawyer. Like I have no qualifications here, but these two impressed the dickens out of me. And I think it would be overstating to say that it's really their client through them, thinks that the judge is impartial. All they're saying is that it would be reasonable to question his impartiality. And that, under Kentucky law, apparently is enough, and the Supreme Court rules. So let's continue. Legal standard for recusal. Under the revised statute and the Supreme Court rule, a judge must disqualify themselves in any proceeding where their impartiality might reasonably be questioned, including but not limited to instances where the judge has a personal bias or prejudice concerning a party or personal knowledge of disputed evidentiary facts. All right, so we're saying they're saying the judge has a personal prejudice or bias. And by the way, it wouldn't surprise me much because they're both judges in the Commonwealth of Kentucky. There are likely going to be times when they're in the same room together. There are all sorts of events happening throughout the year, all the time, where judges might get together. Think of it as like a dental convention or a true crime convention or a high-end audio convention. That's where I've been my whole life, right? If you go to those same events over and over and over again, you tend to make friends, right? Okay, the revised statute authorizes the Chief Justice, when prompted by an affidavit properly certified by the Circuit Court, to, quote, determine whether to designate a regular or retired justice or judge of the Court of Justice as special judge in a particular case. So they're wanting a special judge. The statute is vague regarding the authority given to the Chief Justice when making such a determination, and the paucity of case law exists to guide the Chief Justice's decision. Well, there is a word I have never heard in my life. What is paucity? Paucity is the presence of something only in small or insufficient quantities or amounts. Scarcity. Okay, so you're using paucity instead of scarcity. But okay, so they're saying there is the avenue for them to be able to do that, the authority, though details on it are scarce. However, continues the motion, the revised statute 26A.015 offers guidance regarding when disqualification is appropriate. The statute provides, in relevant part, that a judge, quote, shall disqualify himself in any proceeding where he has a personal bias or prejudice concerning a party or personal knowledge of disputed evidentiary facts concerning the proceedings, or has expressed an opinion concerning the merits of a proceeding, close quote. And that comes from that cited part of the revised statute, 26A.0152A. The statute, man, give me a second. Again, just woke up from a nap. I'm parched. Delicious, delicious reverse osmosis water thanks to Water Drop. Delicious. The statute also requires disqualification where a judge, quote, has knowledge of any other circumstance in which his impartiality might reasonably be questioned. Similarly, the Kentucky Code of Judicial Conduct provides that a judge shall disqualify himself or herself in any proceeding in which the judge's impartiality might reasonably be questioned, including but not limited to the following circumstances. And then they have the little, what do you call those three dots? Dot, dot, dot. It means that there's a little bit cut out, right? The judge, what is that called? I got to stop. I will get stuck on it. The judge has a personal bias or prejudice concerning a party or a party's lawyer. And that comes from the Supreme Court rule, 4.3 Canon 2, Rule 2.11A1. On appellate review of a trial court's determination under the revised statute, consistent with Rule 211, a judge's bias or partiality is determined under an objective standard from the perspective of a reasonable observer who is, I don't know what that parenthetical is, or the brackets, informed of all the surrounding facts and circumstances. The law is full of these reasonableness standards, right? What would cause, in beyond a reasonable doubt, what would cause a reasonable person to change their behavior given a certain set of facts or information, right? Here, it's a standard of the perspective of a reasonable observer who is informed of all the surrounding facts and circumstances. Would it be reasonable for them to believe that there may be prejudice or bias? And then there's other case law. Let's see also Abbott Inc., blah, 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 stating that the objective standard is appropriate for measuring whether a judge's impartiality might reasonably be questioned from the perspective of a reasonable observer who is informed of all the surrounding facts and circumstances. Okay. The goal of these recusal provisions is to, quote, avoid even the appearance of partiality so as to promote public confidence in the integrity of the judicial process. While the Chief Justice's determination under KRS 26A.020 is not a review of the trial court's decision, applying the objective standard to determine whether a judge's impartiality might reasonably be questioned is appropriate, argue the parties. Okay, now we get into the nitty-gritty, which is where we want to be on this channel, right? Both the nitty and the gritty, the factual basis for recusal. A video from a Kentucky judicial take two, everybody, take two. A video from a Kentucky Judicial Commission on Mental Health meeting from September 12th, 2024 has been brought to the attention of counsel for the defense. There is look at this footnote right there. Am I willing to type that in to YouTube? It's on YouTube. I feel like maybe we have to watch it. Let me see, because obviously this is a scanned document. Let me see if I can find a way to easily get there. Give me a second while I use my two screens. You guys are like, this is so unprofessional, Fish. All right, we're going to YouTube. .com / capital KI, capital VB, capital LR, capital X, capital Y, UR, capital U. Let's see if that will just get us to it. Nope. Okay. And then question mark SI equals capital M, capital Y, capital A, 2, capital N, FNL2, VNGK82P. No, it is not finding it. Oh, hold on. I might. YouTube. Yeah, on my side it's not finding it. All right. Let's keep going. I'll see if I can find it and we can watch it another time. Okay. Continuing the motion, the presiding judge did not disclose this fact to the parties despite the close connection in time to the events at issue, leading to an appearance of impropriety. It appears, again, they're not confusing him of impropriety. They're confusing him or accusing him of an appearance of impropriety. It appears that in addition to the speaking event captured in the video, there is also a companion social or dinner event connected to the meeting in some form. During the video, Mullins reports on his involvement with legislative efforts as well as women's with dignity bills. So, yeah, that was a miss something anyway. Mullins also highlights his recent recovery events and expungement efforts in Whitesburg. Mullins then discusses his professional plans for the following week at the District Judges College. When discussing this upcoming event, Judge Coran appears to nod in approval. The fact that these two men served on this very worthwhile committee is not enough to draw an objectively reasonable inference of impartiality. However, there will be proffered evidence that contrasts with the presentation seen on the video. It is difficult to understand how this close proximity with Mullins in both time and distance would not lead the reasonable observer to impute a bias in favor of disbelief of negative statements and the propensity to disallow the same. Wow. Would not lead the reasonable observer to impute a bias in favor of disbelief of negative statements and the propensity to disallow the same. That is a sentence, man. Okay. This is an alleged capital offense in which a judge is the shooting victim. And by the way, I mean, that's kind of important here, right? Judges meet all the time in these conferences, on these committees, at these different events. What's different here is that for the first time in any time that anybody can remember, the victim was a sitting judge. Right? So this is a bit of a sticky wicket, they might say. Right? This is a tough one. The insanity defense centers on the events of this week. They're saying the week that the video was taken, right? And what Mr. Stines believed was afoot with Mullins and his colleague, Daniel Dotson. There is Mr. Dotson's name again. Daniel Dotson, guys, is a local lawyer. He represented Mickey Stines at his deposition, though he was not part of the case. He was not part of the case. Like, I went back to the federal case. He was not part of it. But he represented Mickey Stines in his deposition that happened the Monday before he walked into Judge Mullins' office and shot him dead. And Daniel Dotson is on the witness list. Remember, we talked about that with Elizabeth last week. Let me see if I can find this real quick. No, this is in the Commonwealth. No, Sabrina Adkins v. Fields. Give me just a second. Which witness list is it? It's this one. Okay, let me bring this up. This is in a federal case that started this whole thing. This federal case, if you guys don't know, is a woman named Sabrina Adkins and a woman named Jennifer Hill, who has sadly passed on now, are suing Ben Fields and then Sheriff Mickey Stines and the sheriff's office, now the new sheriff. They're suing them because they're alleging that they should have known that Ben Fields was sexually abusing the women in the Letcher County Jail. And so Mickey Stines goes and does his deposition for this federal civil case, and then starts to apparently get all paranoid, can't sleep, and then walks into the judge's chambers and shoots him dead. Right? That's the connection here. But when we get back over here, let me bring it up so that we can kind of zoom in on it. This is the plaintiff's witness list. So the plaintiffs in this case are Sabrina Adkins. It is Sabrina Adkins. If we go down, they say Daniel Dotson. He is a local attorney. Mr. Dotson is expected to testify concerning his knowledge of Mickey Stein's participation in unlawful sexual activities involving female inmates and of Stein's knowledge of others' involvement in such illegal activities while he was Letcher County Sheriff. Counsel's good faith estimate of direct examination duration, blah, 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 an hour. Okay. So Daniel Dotson, at least according to the plaintiffs in this case, I should say, according to the plaintiffs in this case, Daniel Dotson was aware of and will testify to Mickey Stines being aware of and participating in illegal SA of women from the Letcher County Jail, which would include Sabrina Adkins, Jennifer Hill, and at least one other. But again, as Ned Pillersdorf, when he was a guest on my show, said last year, if there are three, there are 300. In her proffer, Sabrina Adkins said she had seen video of Judge Mullins participating in it. So anyway, that's Mr. Dotson, right? So getting back to the motion at hand, this is an alleged capital offense in which a judge is the shooting victim. The entire case hinges on mental health. The insanity defense centers on the events of this week and the week of the murder, and what Mr. Stines believed was afoot with Mullins and his colleague Daniel Dotson. So having Daniel Dotson in that deposition, man, I think I'm inferring here, right? This is just my opinion based on what I'm reading here. And I think it's reasonable to have this opinion. I think that Daniel Dotson coming to that deposition was probably the trigger. I bet Mickey Stines took that as a direct threat. If you say anything wrong, then it's open season, something like that. And that's what the defense is saying, that the defense has said that their client, Mickey Stines, had reasonable concerns for the safety of his wife and daughter. So anyway, had this video been taken even months prior, then the appearance would not be so concerning. However, this video creates an impression to the public that there is a bias in favor of his colleague seated next to him. As noted in a recent order from the court, videos create a strong presumption that is extremely difficult to rebut. Yeah, I think videos do create a strong presumption that is extremely difficult to rebut. And the fact that they released this video and others is just shocking. And also, like heartwarming to me that they would do that. By the way, I should shout out to the court staff who make it so easy for us to get publicly available documents in this case. We don't even have to ask anymore. I don't. I'm on a list of reporters that just get it whenever there's something new. It's so amazing. They are terrific. I just love transparency in government. I just love it. Okay. By way of example, at the juncture when the foregoing was discovered by the defense, a hearing on bond was set. However, despite the consent of the defendant, the mental health report from the state's own expert has been disallowed as evidence in the bond hearing. While the undersigned is restrained by the previous order from discussing the findings in the report or the contents, our client made multiple revelations to the examiner that fall into the category of evidence that would conflict with this judge's professional knowledge of the deceased. That is such careful language. We're not saying that it is. We're just saying that it may appear to conflict because of this appearance of impropriety. That's very carefully worded language that is kind of a shot across the bow as far as I'm concerned. It's a shot across the bow. Judge, you need to recuse yourself, and we need to find a judge that has no bias or appearance of bias. That was a full-on shot across the bow, man. Okay, at this point, there has been no legal basis as support for the refusal to unseal the KCPC report. While that issue is one to be addressed further at a later date, the objective observer would rationally believe there is inherent bias from the video, and this would lead the judge to prohibit this normally admissible report from coming into evidence. Shot 2 across the bow, it's getting a little closer. Targeting is getting pretty accurate at this point. The undersigned has known the presiding judge as a former prosecutor and as a judge and does not seek his recusal lightly. Okay, we're gonna butter him up here a little bit. However, the eyes of the world have been upon this litigation. The visual optics in this case must demonstrate impartiality. I wonder how judges feel about this. I didn't get a picture of Judge Christopher Corin. I don't know if I'm pronouncing that right. I did in the thumbnail, but actually, I can bring it up. I know how to gets it. Let me, yeah, this isn't a, there we go. Here is Judge Corin, right? This is the guy that has been presiding. No, wrong button, Gavin. No, Gavin. There we go. This is the judge, Judge Christopher Corin. Okay, so we're not doing this lightly, Judge. We know you're a former prosecutor. We know you're a good guy. I wonder how judges feel about it, though, having their impartiality called into question. Maybe they're like, you know what? There is an appearance of impropriety here. Let's move along. I don't want to be part of this anyway. Possibly, or it could be like, dude, you're impugning my character. And they clutch I don't know. Had this very recent meeting and sharing of accolades been disclosed previously, then the evaluation of the circumstances might differ. Another shot across the bow. Had you told us this? However, there was no previous disclosure. Okay, and then it continues with, I think, it's not much more. Timeliness of motion. This motion is filed immediately upon discovery of the facts upon which the disqualification rests as required by Kentucky law. Okay. Once they found out, they said they filed the motion. Okay, recusal. The circumstances described above fall within the recusal provisions of KRS 26A.015 and SCR 4.300 Canon 3E1 as they create a reasonable question regarding the judge's impartiality. Wherefore, the defendant respectfully requests that this honorable court grant this motion and recuse Judge Christopher Corrin from further proceedings in this matter. Respectfully submitted, Jeremy A. Bartley and Carrie N. Bartley, the counsel for the defense. And there's not much more other than like the verification and stuff like that. So that's where we are. Now, I want to hear your thoughts on this. We're going to read through your thoughts and or at least through your comments, and I would love you to tell me if you think that this is proper, and if this is, I mean, what is this going to do? Is this going to push back the trial? Probably. But does that matter? Does it even matter? I don't know that it does. Let's check in with y'all on your comments here. It's just refreshed. Let me just let's see. Seal Beach is in the house. We'll bring up our victim here. Glad you are here. Valparaiso. Yeah, guys. Virginia is here. Vincennes, Indiana is here. Tecumseh, Michigan. You guys are awesome. Northwest New Mexico. Awesome. Scotch's mom, Gavin, lose weight and bond with my new little black kitten. Man, I asked you for your New Year's resolutions. Okay, Scotch mom, that's great. Lose weight and bond with your little new black kitten. That's cute. That's adorable. You know, no, I'm our daughter and son-in-law have a black cat, and he has the most piercing yellow eyes. It's just so much fun. He's such a handsome boy. So yeah, I hope you do it. Mooney said, yep, we were road tripping. Faux show. Erie's in the house. Shay says, I love the way you talk about your spouse. So sweet. Happy New Year. Thank you very much. Kimberly is my snuggly bear and my one and only. And my sweetie pie. She's awesome. I will tell you this though. I am a bit of a tease, and she does have to put up with a lot from me. I jab every once in a while, right? I like to tease, and she is such a good sport about it. So good. Missouri in the house, freezing in Jersey. Yeah, as we passed through New Jersey yesterday, it was muy coldo. Let's see what else you guys are saying. Suspension dots are what they're called. Ellipses. That is the one that I was looking for. Ellipses. Thank you. Thank you for that. It doesn't want to go. Keep going. Bobby McRae from Kansas City. Glad you made it. Okay. Georgia says, the video shows Mullins and Corrin sitting side by side. Mullins speaks during the meeting. Mullins' wife was present also. The chairperson of the committee is now the Chief Justice, Lambert. I'm gonna check out that video. Maybe I can share it to the tank. Speaking of the tank, y'all, just a quick reminder that we hang out on the Book of Faces. Where's the right button? There we go. On Facebook, in the fish tank. We are a growing cadre of true crime aficionados and just overall true crime nerds. We talk about all sorts of different cases. This is a case we might want to talk about here on the channel. Yeah, a little bit. Look at Sweet Tater there taking pictures for Elizabeth. We have all sorts of things going on over in the tank. You're always cordially invited to join us over there in the tank. Let's bring up Mickey Stines this time. So thank you for that, Georgia. See if there's anything else. Okay, Georgia says, my question is, why didn't Judge Corrin say, no, I was sitting with Mullins at a mental health committee meeting 1 week before he was murdered? Did he forget? Or did he not think that it was sufficient to recuse himself? He might say to this motion that a reasonable person wouldn't think that this is going to give the appearance of impartiality. That's not a reasonable thing. He may deny the motion. Completely possible. Maybe he remembered and just was like, but we're judges. We go to conferences. We see each other. I don't know. Do not know. Let's see. George also says, wonder why the federal judge didn't hold Daniel Dodson in contempt for failing to make an entry of appearance as Mickey's attorney, failing to make later court appearances, blah, blah, blah. Yeah, he had not made an entry of appearance in that case. He just was there that day, kind of saying, hey, should we take a break? And taking Mickey outside during the deposition, probably to give him advice. Or, well, I mean, is the inference that he was threatening Mickey? That might be the inference. I don't know if it's reasonable to believe that. But anyway, I don't know. Georgia, I don't know. She continues, and failing to withdraw his counsel. Georgia, you are on fire here. She also says, it appears and also sounds like Daniel Dotson's appearance at Mickey Stines' deposition was designed to intimidate the witness, Mickey being the witness. So you just said what I wondered. And Georgia says, the judge should recuse, absolutely, and his rulings so far should be set aside. Okay. Mel Stiller, black cats with yellow eyes are embers to be admired. Yeah, he's a handsome boy. The good professor. He has a long name, and one of his honorifics is professor. Georgia continues, Gavin, under the judicial ethics, it's the appearance of impropriety or bias that matters. Well, if I can quibble, because I'm a professional quibbler, and this is just devil's advocate here, it's more than the appearance of impropriety or bias. It's under the reasonableness standard, right? Would a reasonable person believe that there is an appearance of impropriety or bias? And we can't forget that part, because that reasonableness standard is a legal standard. Now, I think I lean more your way, Georgia. I think that I think this does look bad, and I think that it is reasonable to believe it looks bad, that there's an appearance of impropriety here. But will the judge agree? Him being a former prosecutor, a sitting judge with law school and years of experience, will he say it's unreasonable? I don't know. I do not know. That's but again, and she says that's actually a low bar. It doesn't mean the judge did anything wrong, but it looks bad. Yes, indeed. Yeah, and the Barleys, I think, have been very careful. I mean, there were a couple shots across the bow, but they were very careful not to accuse him of anything. Hey, while I've got this one, I am in your rewatch club. Glad. I love the rewatch crew. Thank you. Live in West Cliff, Colorado. We live in a really small town in the Wet Mountain Valley. Awesome. Awesome. Ohio Palm Mom says, I think I'm reasonable and think it looks improper. So, yeah, could be. You guys might be right. And I agree with you. I just also I'm curious what will happen. I don't know. That's what's happening in the case. Now, we actually don't have too many, but we do have a headline to get to. Let's do it.
True crime headlines.
Pow! Okay, guys. I didn't get a bunch of headlines tonight. In fact, this is the only one. Why? Why didn't I spend the time to get a few headlines to talk about? I would like to refer back to Exhibit A, the fact I'm still in my jams. I'm in my jammies right now, and was in the middle of a delicious nap. And when I finally woke up and came to my senses, I'm a slow waker. So this is the one that I'm going to bring to you. This is Court TV's most anticipated trials of 2026. I am wondering which one you're looking forward to the most. I have one. It's a couple down on the list. And I think there's only a couple here, but Georgia versus Sarah Grace Patrick. Now, this is a case that I have not covered on the channel, but she is charged with 2 counts of murder, 2 counts of aggravated assault in the deaths of her mother, Kristen Brock, and stepfather, James Brock. She's 17 years old. Couple was fatally shot in February 2025. I don't think that's going to be a trial in 2026. Come on. That'd be on the fast track. Virginia versus Brendan Banfield, who's charged in the deaths of his wife, Christine Banfield, and Joseph Ryan. Christine and Ryan were fatally shot in the Banfield's Virginia home on February 24th, 2023. Investigators have said the murders were part of a larger scheme between Brendan and Juliana Perez Magal, who were having an affair. Dun, dun, dun. So Brendan wanted to off his wife. Ooh. And who is Joseph? That's one that I haven't followed either. Have you guys followed these? Okay, this is the one that I've been following since 2022. This one is wild, and it comes from it happened in basically where I come from, where my grandparents were born and raised. This is the case of Utah versus Corey Richins, who is charged with the murder of Eric Richins. He was killed in 2022 by a lethal dose of fentanyl. Lethal dose being an understatement for a dose big enough to kill like a herd of elephants. It was so much, which prosecutors say Corey put into his drink to kill him and cash in on his life insurance. She was having an affair herself, and in a display of chutzpah, of again elephantine proportions, Corey then wrote a children's book about grief. Her children, the cover has Eric looking down from heaven upon his children. So her murder trial begins next month. I'm really looking forward to that one. New Mexico versus Isaac Apodaca. He's charged with coercion after his girlfriend, Kiara McCauley, murdered Grace Jennings with a sword at her home in October 22. I remember this one. And I don't mean to make light of this because we take victims seriously and their families seriously, but we don't take ourselves seriously. But I do remember when I learned about this case, the whole Serenity line. Mal, he killed me, Mal, with a sword. How crazy is that? I think is the line. Or how wild is that? Something like that. I was like, with a sword? It's 2020 with a sword? Both McCauley and Apodaca claimed they had previously been in relationships with Jennings before dating each other. McCauley pleaded guilty to second-degree murder charges in exchange for testifying at Apodaca's trial. That also begins next month. Bahamas versus Lindsay Shiver. She's accused of plotting with her boyfriend, Terrence Bethel, and another man, Farron Newbold, to kill her then-husband, former Auburn football player Robert Shiver. She faces charges in the Bahamas, where she and her husband had a second home and where she allegedly began her affair with Bethel. That's expected to start in the trial in March. I'm curious what that trial is going to look like, considering the Bahamas are a Commonwealth nation, are they not? I can't remember. Let me look it up. Are the Bahamas a Commonwealth nation? Yes, that's right. They were an independent country that joined the Commonwealth of Nations in 1973 after gaining independence from the United Kingdom. That's what a Commonwealth nation is. They recognize the British monarch. So we're going to be looking at a British style of justice here. California versus Larry Millette, charged with murder and illegally possessing an assault weapon in the death of his missing wife, 40-year-old Maya. Prosecutors have claimed Larry killed Maya because she was looking to divorce him. Maya, who shares 3 children with Larry, disappeared in January 2021. Her body has not been found. Another no body one. A couple others, Massachusetts versus Lindsay Clancy. That one is expected in July. Strangled her daughter 5 and sons 3 and 7 months. Move along. Shanna Gardner, charged with the murder of Gardner's ex-husband, Microsoft executive Jared Bridigan. That's supposed to be in August. Virginia versus Naresh Bhatt, charged with murder and defiling the body of his wife. That's supposed to be in October. I'm looking forward to the Corey Richards trial. Curious what you guys think about that. Okay, so those are our headlines. Let's finish it up tonight, shall we? 3 questions.
It's 3 questions with Gavin Fish.
Pow. Okay, you guys know the rules. In this segment, I answer 3 questions that were submitted by you. Hey, no harm, no foul here. I'm not angry about it. I'm not even mildly tiffed at it. But there are a couple of you that have sent the same questions multiple times. You've forwarded me your old email, your previous email, as if I hadn't answered those questions already. And I'm telling you, I have. I have answered your questions already. So come up with some new questions and send them my way, will you? Okay, so in this segment, I answer 3 questions. You can email them to me, 3questions@gavinfish.com, 3questions@gavinfish.com. It's spelled out THREE questions at gavinfish.com. You can send 1 question, you can send 100 questions. There's no limit to how many questions you can send in or how many times you can send them in. I just promise that I will answer 3 questions at a time. And I have a cute little spreadsheet that I use to track the questions, whether I answered them or not. I think what I should probably do is put a date when I answered them too, and I add a column. But anyway, you can ask me anything. It can be challenging, hard questions about the mysteries of the universe. It can be, what's your favorite candy bar? And speaking of that one, that is the question that I am faced with right now. What is your favorite chocolate, sweet/candy, and do you share it? Well, dear questioner, I think I'm boring on this one because it is the most popular candy bar in the world. It is the delicious, the gratifying, the hunger destroying a humble Snickers bar. I love me a Snickers. Now, I've not had one in months. Why? Because I was a big fat fatty. Big fat fatty. And needed to drop some LBs. Now, I still am on that journey. But it's funny that you bring it up because just yesterday, as we were working to move our daughter and son-in-law from their 5-story walk-up to, thankfully, their 1st-story apartment in a different borough, my sweetie pie, my snuggly bear, my one and only, was getting a little hangry, and she recognized it, and she was starting to shake. We had not eaten for many, many hours. Multos horas. So we went on down to the Quickie Mart on the corner of Broadway and West 155th and got her and 2 others a giant Snickers bar. I did not partake. I wanted to partake, but I did not because of the aforementioned bigness, fatness, and fattiness that I once was, and really still am, but I'm doing better. And do I share it? Well, listen, if I were to get a birthday gift, let's say that one of you dear viewers went to my website, went to the support me tab and saw that little PO box, and you're like, I'm going to give Gavin the gift of a bag of Snickers. There is no way that I would let anybody know that I have them. I would eat them all myself I would engage in all of the tradecraft to hide the fact that I had the Snickers. They would not be anywhere where they could be found because my wife has demonstrated to me over our 26 years of wedded bliss and our like 3.5 hours of pre-wedded bliss. That's a joke. We knew each other 5.5 months when we got married. Um, she has like bloodhound capability of sniffing out chocolate. And I used to like grab M&Ms or something. I love peanut M&Ms, and she will eat the M&Ms. This is listen. I'm not speaking out of school here. She will admit to this, but she doesn't like peanut M&Ms. She likes peanut butter M&Ms. So if I were to get like peanut M&Ms and hide them in what I thought was a reasonable place, underneath like the vegetables that nobody wants to eat in the freezer, no, she can find them and she will eat them even though that she doesn't want them. And let's say for example, now this sounds like I'm complaining about my sweetie pie snuggly bear, my one and only. No, people are complex creatures. They can both be angels on earth and also thieves and robbers of my delicious candy. And that is what my beloved is. Even if she doesn't like it, she will eat. She will take it and she will eat it. So I have developed a complex piece of tradecraft to keep what I eat away from my wife. Now, this also goes to the fact that I am a big fat fatty. I was doing it too much. But yes, thank you for that question. I probably droned on too long about it. Number 2, are you a planner or a wing it person when it comes to everyday life? I am neither and both. I'm a person that can plan my day and or plan a week or plan a trip or whatever, and it's totally cool if it doesn't go to plan. I have found that I am happiest when I'm not so uptight about things going my way. Now that hasn't always been the case. I've grown into this as now an older man. Yes, I'm an older man. I'm over 50. Come on. I'm not a young man anymore. It's taken me years to get to this point, but it's way, way, way better if you just let it go if things don't go your way. I don't mind winging it every once in a while too. I don't mind going into a day with absolutely no plan. In fact, tomorrow, which is Saturday at the time that I'm speaking this aloud, I have no plan. Period. I will do nothing. Now, I am currently seated in the world's messiest home office. I have been going through what I am referring to as my post midlife crisis, where I am just stuck in a pit of never ending nostalgia induced joylessness. Not permanently and not every moment of the day, but I'm just being driven to go through everything in my life previous, and my floor is covered with mementos and think. Let me give you an example. Let me just reach down. I'm going to give you two. I'll give you. Okay, these were just on my floor. Okay, this is a plastic and foam seat that I got. It smells so mildewy, but I got it from my 6th grade teacher, Mr. Bob Bales, Trajan Elementary School, Orangevale, California, in 1986. And here I have it, all covered with mildew and grossness, but I can't let it go. I can't let it go. I love it. I haven't looked at this in 2.5 decades, but I love it. And that it is sitting on my floor right now. Um, here, here is a warped book of Far Side cartoons that, I mean, this was published. When was this published? It doesn't say. Come on, Gary Larson. Doesn't 1985. I have I've probably had it since close to then. because I love The Far Side. I have not opened that. That was the first time I've opened this book in 3 decades, I'm sure. This, what is this, you might ask? What is it? It took me forever to figure it out. This is a mechanism from the inside of an old overhead projector that I used when I was maybe 16 years old to create my first projection TV. I was learning about optics. And this is a leftover bit. For some reason I packed it in a box. But boy did it bring back the memories of watching Star Trek The Next Generation on a giant screen in my little bedroom at home when I was a kid. So anyway, yeah, I think I do tomorrow need to go through that stuff, but I don't really have a plan to. I think I'm gonna wing it. All right. Last question. Are you an early riser by choice, or are mornings something you endure? Mornings are something that I endure. I have learned that there are people can be divided into two camps. There are people that when the alarm goes off, they get up. And then there are people that have to hit the snooze button 9 times. I am in the latter group. I have a real hard time getting up. So when I laid down on our old purple couch to take a little snooze because I was exhausted because I just didn't have enough sleep overnight, it was supposed to be 20 minutes. It ended up being probably an hour and 45 minutes of me hitting snooze, snooze, snooze. It's just hard for me to wake up. It's the way I am. Kimberly, the aforementioned Snuggly Bear, dude, the alarm goes off at whatever time it is she likes to get up before the sun. And she's just up exercising, having her little moment where the house is quiet and it's just her. She loves that. I do that after everybody goes to bed. She does it in the morning. And it used to be that I would like get up at 7 o'clock to go to the bathroom. I worked from home, so and I would be like, just like walking and then return back to our bedroom, and she would make the bed so that I couldn't climb back in it, thinking that that would help somehow. I would just fall upon it, and yeah, it's taken us years to negotiate this wedded bliss, right? Those are our 3 questions.
It's 3 questions with Gavin Fish.
Okay, so a couple last comments before we call it a night. Debbie says, Gavin, didn't Richens get moved to May? I'm not sure. I'll have to take a look at it. But now that you mention that, I will. Ohio Palm Mom says jammies are the best. Yeah, I like sweats from a jams. Last little comment from Georgia says, your crime show is one of the best. We don't see any clutter from here. You seem very organized in your thoughts, calm and controlled. Well, thank you. I'm glad that I come across that way. I keep the camera up high. The floor is just covered. It's just covered. Here is a pile of Batman the movie cards from 1989. This is just that might be a tenth of what I have kept. Why I would buy? I mean, I was into Batman, man. I was Tim Burton's Batman, but I've got hundreds of these, and they're just on my floor. All right, guys. Thank you so much for your comments. Thanks for joining me tonight. We will be back on Monday with another true crime discussion, a true crime conversation with me. Remember that you can always reach out to me on my website, gavinfish.com. There's always a link in the description down below. Remember that I publish Crime Cod, which is a true crime news website that you're welcome to go and read at any time. If you just click on this link on my website, that will load CrimeCod, or if you load one of these, click on one of these articles, it will go directly to the article. I am so grateful to those of you who support me in all the ways: watching, liking, commenting, subscribing. I love the tips that I receive in the tip jar. I love my patrons. I love you guys, the members of YouTube. Thank you so much. And also supporting me by joining the fish tank. Looks like we're coming up on 5,900 members. What are we at now? 58, 57. So it's a growing little community. I deeply, deeply appreciate you all. Speaking of my patrons, I will quickly, after this live stream ends, I will publish all of the docs that I recently got in the Mickey Stines trial onto Patreon for you to check out there. With that, I shall bid you adieu. Thank you very much for joining me tonight, and I will see you on the next one. Take care. Thank you very much for watching this video. If you liked what you saw, please consider subscribing. And if you have any questions or comments, please leave them below.